Bill, ready to go?
Go ahead.
All right. Well, good afternoon. My name is Caleb Knight. I'm an associate and healthcare attorney at Clarity Sense of Nassau, PLC, work with Bill and Todd. And I'm going to do a presentation on HIPAA and the HITECH Act that made some changes to HIPAA, and then talk about some recent changes under both of those acts.
Caleb, I'm having some problems hearing you. I don't know if Adrian's having issues with audio. Can you hear him enough, Adrian?
I can hear him here, but
okay, go ahead.
if you can speak up, that's...
Yeah, I can try to speak up a little bit.
Thank
Sorry.
you.
You can come sit in the front row, Bill.
Yeah, that means I have to get up.
I'll call you out.
Thanks.
Well, basically, HIPAA and the HITECH Act, they're pretty... a lot of people have a general understanding of what they stand for, but to understand some of the nuances and the actual rules and regulations takes more of an in-depth understanding. And I'm not going to be able to provide that today, but I do hope that I can provide a little bit of background and sort of a basic introduction to what HIPAA and what HITECH are. So I'm going to do it in two parts. Part one is going to be an introduction, and then part two will be some of the more recent changes to those laws. So what is HIPAA? HIPAA is the Health Insurance Portability and Accountability Act. All right. It was enacted by Congress in 1996, so it's been around for actually some time now. And this is the general rule. A covered entity may not use or disclose PHI, or protected health information, unless required or permitted by HIPAA. And we'll get into what protected health information is in just a minute. But the law provides you to disclose information if it's required or permitted under HIPAA. So in some instances where it's required are to an individual patient or to the Secretary of Health and Human Services to determine your compliance under the law. Permitted disclosures are for treatment, payment, and healthcare operations. That's an exception that we're going to talk about a little bit. Basically, any kind of basically anything that falls into those categories, treatment, payment, or healthcare operations, is it's a permitted disclosure under HIPAA. And of course, if a patient authorizes the disclosure of their medical information, then that also waives the HIPAA protections. This is a list of other other permitted disclosures under HIPAA. You can look at the list there. It's basically, for law enforcement, for health oversight, basically just different sort of exceptions that have been carved out under HIPAA to allow for disclosures. So what type of information is protected under HIPAA? There's two definitions that are important under the part of the law titled Administrative Simplification. The first is health information, and the second is individually identifiable health information. And I've got the definition of health information there for you. It basically just means anything that's created or received by a provider that is health information. The second step to that, or the second definition, individually identifiable health information, is basically what makes it protected. Basically, you're taking the health information and you're adding the fact that it identifies you, you're adding that into the picture. So it's not just health information, but it's health information that is identifiable, somehow linked to you, whether it's your social security number, your address, your name. It's basically a combination of those couple definitions. And that's what is considered protected health information, or PHI, under HIPAA. And you can see there basically just a summary of what protected health information is. Now, the security rule, which we're also going to talk about here in just a minute, is a subset of protected health information, and it basically applies to protected health information that's in electronic form, because more and more we're seeing health records and patient charts and whatnot being stored digitally as opposed to paper records. Now, HIPAA also provides a number of different rights. It includes patient rights to request restrictions on their communications about their patient records, a patient right to access or inspect records, the right to amend records, the right to obtain an accounting of disclosures. That's something else we're going to talk about here in a minute. The right to file a complaint, and the right to a notice of privacy practices. And I mentioned earlier that a patient can fill out an authorization to allow the disclosure of their health information. And so I want to go over briefly what an authorization can do. Basically, again, that if there's an authorization in place, then that allows for a healthcare provider to disclose a person's protected health information, and it's not been subject to HIPAA. Now, there are some requirements for those authorizations. There's special rules in place for psychotherapy notes and for marketing, and generally you can't condition the patient's treatment on whether or not they sign the authorization. Now, when HIPAA was originally enacted in 1996, there was a provision that rules would have to be promulgated by the Department of Health and Human Services. And two of those rules, and the two most important of those rules, are the privacy rule and the security rule. The privacy rule, it's found in subpart E, covers around 40 pages, and the compliance date was back in 2003. So it actually came about quite a while after the 1996 enactment of HIPAA. Basically, the privacy rule provides a federal floor for privacy protections. So states all throughout the country are free to enact more stringent privacy rules, but the federal privacy rule is basically the floor, in that you can't fall below that. Now, under the privacy rule, there's certain security standards that have to be in place. Basically, it involves both physical safeguards, such as it can be guards, locks on doors, equipment or records being kept in secured locations. But it can also be, and does often include, technical safeguards, including passwords, encryption, and software solutions. So it's important to understand that under HIPAA, patient information can be protected both if it's in its paper form and also if it's in a digital form. Now, the other rule that I mentioned is the security rule. Under the security rule, it's a little bit shorter. It only spans 8 pages, but it's more technical. And actually, the security rule actually only applies to records that are transmitted in electronic form. So while the privacy rule applies to all medical records, the security rule applies to only the electronic records that are kept in electronic form. So now that we've gone over what privacy and security rules are under HIPAA, we're going to talk some about the more recent HITECH Act. And that stands for the Health Information Technology for Economic and Clinical Health Act. It came around back in 2009 as part of the American Recovery and Reinvestment Act, so it's much more recent than the original HIPAA legislation. Passed on February 17, 2009, and basically it did a lot of things to HIPAA, and we're going to go over those sort of in more detail now. So we're going to talk about how the individual pieces fit together and how HITECH actually changed HIPAA. So the HITECH Act, it widens the scope of the privacy and security protections under HIPAA. Now, under HIPAA, the rules, the privacy and security rules, applied only to covered entities, meaning hospitals, doctors, and whatnot, and then also to their business associates. One of the most important changes under the HITECH Act is that now the HITECH Act and HIPAA generally apply to covered entities, business associates, and also subcontractors. So basically, Congress has expanded the number of persons that are going to be held liable in the event of some sort of disclosure. And you can see it increases the legal liability for noncompliance with the regulations. So basically, as I said, HITECH, what it's done to HIPAA, it expands and clarifies the definition of a business associate, which basically falls underneath the covered entity. It also modifies rules on marketing and fundraising. It prohibits the sale of protected health information without an authorization. And it basically puts into place several more potentials for penalties under both of those acts. A business associate, like I said, they're subject to the HIPAA privacy rule requirements, including penalties for violations. They used to just be contractually liable, as between the covered entity and the business associate. Now, both business associates and subcontractors are liable under the actual rule, meaning that business associates are now subject to the original rules regarding physical and technical safeguards, and that goes back to the idea of locks on doors, passwords, software systems, and other safeguards. Yeah.
Okay, is there any protections against, let's say, not the healthcare companies directly or the contractors, but let's say your local place where you're employed and your HR leaks some information?
Well, it would depend. If I mean, it depends on what kind of company you're talking about. Are you?
Let's say you work for an ISP, and your HR leaks information about, what your insurance has been paying for, some health issue that you have that you had to report to HR because you were taking time off.
That would probably fall under the exceptions, and I think that's probably a few steps removed from the protections of the rule. Your insurance company would be the covered entity, I believe, as a healthcare operation, and then your employer would probably be the business associate then. But I think that there would probably be an exception that would apply there.
Just curious, thanks.
Well, you say that the business associates are now responsible for the physical security.
Yes.
So like in a hospital where they have to have locked doors on the medical records and all that kind of stuff. For like a home health care agency, would they be subject to those kind of things where they have to have?
Yeah, they would also be subject to the physical safeguards. And this is sort of an aside, and it's not really completely related to your question. One thing I found interesting as a healthcare attorney, a couple months ago when the tornadoes tragically struck Joplin, Missouri, one of the news articles talked about a hospital that their records were basically obliterated. And records were found counties over. And unfortunately, and I don't think that they would actually do this, but the Department of Health and Human Services could actually go after the hospital and see whether or not they had reasonable physical safeguards in place. And again, a lot of that does, if you have the policy in place, that can protect you to some degree. I mean, there's only so much that you can do, obviously, to protect against a natural disaster like that.
Right.
But again, as a healthcare attorney, I thought it was pretty interesting that a hospital could be held liable basically for penalties when something like that happened. But to go back to your question about home health agencies, yes, they would be responsible for protecting the healthcare information. Now, the key point with regard to subcontractors is that both business associates and the subcontractors now have to implement the privacy and security rules as if they were the covered entity. And there's sort of a chart there. You can see that the information might be passed from the covered entity to the business associate to the subcontractor. Yes.
Sorry to interrupt you.
Sure.
So this would also, so let's say the business associate who's now covered under HIPAA by HITECH passes that off to state settlement document shredding service. They also have to abide by the same.
There would have to be a business associate agreement in place between the business associate and that document shredding subcontractor, and the subcontractor would be held to some of the portions of the privacy and security rule as well. Basically, it really expands the scope. The HITECH Act expands the scope of HIPAA.
Who's going to audit the contractor in this particular example? You have the shredder.
The state attorney general actually has quite a bit of authority to go after.
No, not go after them, audit them.
To audit them.
Like I'm a healthcare agency. I contract you to do shredding,
Sure.
and you fail. Do I get any penalty for not checking what you said you was going to do?
For not.
Yeah. Do I get anything for not auditing your business?
It's going to be audited by the federal.
I believe the Office of Civil Rights is now saying that they released a contract to set up a framework to start performing audits, which is also mandated by HITECH.
Right. There's actually.
They're going to go out and start spot checking a lot of this stuff.
There was actually, I think I had it here somewhere. There's, as part of the HITECH Act, there was around $9.5 million, I believe, that was set aside specifically to set up an auditing framework for checking in on business associate agreements and for the relationships between business associates and subcontractors. So, but yeah, the Office of Civil Rights is one of the primary agencies that's going to be in charge of audits.
That's for audits. You're saying they're going to be in charge of audits.
Yes.
So I hire you and I think that you've got a problem. I go talk to the civil rights, and I don't have to expend any of my energy to make sure that you're doing your duty.
Right.
What I hired you for.
Well, what do you mean hired you for?
If I'm a covered entity, and I hire you as a shredder,
yes,
and you don't perform, some of the documents get out.
Well, now if it's so you're saying that if there's a contract between you and me as the shredder,
As the BA,
you'd still have a private right of action for breach of contract that you could enforce against me, but you could also report to the civil rights and have them audit and see whether or not there's been a violation of the HITECH Act.
right.
Okay, so you still maintain a private right of action.
But will I have any problem with not auditing you during the portion of the contract that's before the incident, before the release? Let's say, I'm working with you for a year. We started in January, and we have a BA agreement in effect. In August, you fail, and these records get out. Okay, now the time between January and August, am I required to audit your business for proper HIPAA practices?
I don't believe so, and I don't think you would have to unless the particular business associate agreement that was set up between you and the shredder would require that.
Gotcha.
I'm not sure. That's a good question, though. I'm going to have to look into that now.
We've been fighting that one for a long time.
Have
I
you?
was hoping maybe you had come up with something.
Yeah, no, I haven't. But I'd be happy to take down your information, maybe take a look at it for you.
Actually, I don't work for that agency anymore. I used to
Okay.
work for PEIA.
Okay.
And we battled that one because
Was it a shredding company? Was that
I was everybody.
okay?
Whose responsibility is it to audit the VA? Who's is
I
it?
think it's
Because
the
we
Office
didn't
of
want to do
Rights.
it. We were
Right.
a healthcare insurance company.
Right.
We didn't want to get in the business of auditing other companies for HIPAA compliance.
Right. Yeah. I mean, there's supposed to be steps in place. The government's supposed to put in, basically establish that auditing framework. But I think that's still in the works.
Yeah, no kidding. Man.
But we are seeing more and more enforcement actions taken under HITECH. It seems like every couple of days we read a new news report about the settlement reached.
Oh, it should. It had to have come. You have to start enforcing that stuff sometime.
Right.
Oh my goodness.
Right. Well, and you can see how long it takes for. I mean, the HIPAA was passed in '96. The security and privacy rules didn't come around until 2003 and 2005. It's almost 10 years later. Now, the HITECH Act came out in 2009. We're seeing rules just now being promulgated, 2 years later. And one of the rules I'm going to talk about later, the Accounting for Disclosures rule, doesn't actually take effect until probably mid next year. The final rule was just announced for the comment period. So there's a really long delay between when this stuff comes out and when it actually begins to be enforced.
It's a lot of money, isn't it?
Yeah,
Just to execute this particular rule set.
it is.
Right.
Well, I'm going to jump back in here to something we see fairly often, the federal breach notification. We're hearing more about this, like I said, pretty often now. If there's a breach of health information, it has to be reported to different places. And basically, the HITECH Act puts together a framework of when, how, and to who breaches have to be reported. Breach notification is required, as you can see, for HIPAA-covered entities, for business associates, and for PHR, personal health record vendors. So basically, if there's a release of information, and that information falls within the definition of PHI, meaning that it's not just health information, but it links to you somehow. It's social security number, name, or address. That has to be reported. If it's the disclosure of less than 500 individuals, the reporting is just done on an annual basis. If it's more than 500 individuals, the reporting is done immediately to HHS, the Department of Health and Human Services. And you can see there, a breach is a impermissible use or disclosure under the privacy rule that compromises the security or privacy of affected health information. That can be, we heard a couple months ago about a law firm closed down, and the attorney basically just took all of his client records and put them in the dumpster, and someone happened to be looking around outside and came across these stacks and stacks of patient records that had been turned over to the attorney, and he had just thrown them away. Well, that obviously would be a breach under the breach notification law. Notification, as I said, is required at different times. Generally, for larger breaches, you have to notify HHS within 60 days. Smaller scale breaches, there's a different notification timeline. You can see here when you have to notify and to who. Basically, it is the Secretary of Health and Human Services that needs the notification. There's a requirement that you notify the individual whose health information has been compromised. So there's also that requirement that, say, if you're a doctor and somehow something happens and the patient's records are disclosed, you have an obligation to send letters to your patients and let them know that their client information has been breached. And now I want to talk briefly about the enforcement of penalties. As I mentioned, there's sort of been an upswing in the number of these. Enforcement is through civil and criminal penalties. There's civil penalties under the Office of Civil Rights and State Attorney Generals, and there's also criminal penalties available under the Department of Justice's jurisdiction. You can see there that the civil penalties are varied. They can depend on whether or not there was willful neglect or not, and that basically puts you into a higher category as far as the penalties that you can be assessed. And by way of example, just last week UCLA announced that it settled a disclosure for $865,000. There had been two celebrity patients that had checked into UCLA's medical center, and basically the medical staff, once they found out that these celebrities checked in the hospital, were going to their computer workstations and accessing the patient's information to see what they checked in for. I mean, that's not hard to imagine, right? You've got a curious nurse that wants to see what. I actually heard that the two celebrities were, I think, Britney Spears and Farrah Fawcett. But you've got nurses basically checking up on what these celebrities are checked into the hospital for. And if there's not a reason for that medical personnel to be accessing the record, then that's something that shouldn't happen.
What's your per record cost these days?
What's that?
For a breach.
It's actually pretty hard to pin down. You mean per patient cost, or?
No, per record. If you release 670,000 records or 50 records.
I'm actually not sure. That information is compiled on the I think on CMS's website. Actually, they have pretty good breakdowns by state that basically break down. Say they have, just as an example, 1,000 breaches reported. Mm-hmm. They'll have 40% that they investigate and find out that there wasn't actually a breach, and they'll break down what happened in the others, whether it was a settlement, and for what amounts. I'm not sure what some of the settlements are now. I know that they picked up one of the other charts available on the website basically shows by year the number of these enforcement actions that have been taken, and they've really, increased at least 4 or 5-fold since.
Oh, really? Because less than 5 years ago, it was $200 a record.
Yeah, I'm not sure what the actual cost is now, but and it might not be that the cost per record is higher. It might just be that there's being more and more of these assessed.
Right.
Well, I say congratulations, you understand HIPAA and HITECH. That might be a little bit of an overstatement because it's pretty hard to wrap your head around what the rule actually means. But I'd like to talk about some recent changes under HIPAA. Most importantly, the accounting for disclosure. I think this is kind of pertinent to what this conference is about. The Health Information, use the abbreviation, the HITECH Act requires that the Department of Health and Human Services remove the exception for treatment, payment, and health care operations to the extent disclosures are made through an electronic health record. So importantly, this new rule only applies to electronic health records. But as I talked about before, there's an exception under HIPAA for disclosures that are related to treatment, payment, and healthcare. And one of the problems was that that exception, with when you're dealing with accounting for disclosures of healthcare information, the exception basically followed the rule, because so much of the use or the access of patient health records or personal protected health information is for treatment, payment, and healthcare operations. So in effect, that exception swallowed the rule. So basically, under the new rule, that exception is out, and if it's an electronic health record, the provider has to provide patient with an accounting of all disclosures. That's it, basically all disclosures, not these disclosures that fall outside of the old exception. So importantly, this puts a pretty big burden on a covered entity, because basically what you've got with the accounting for disclosures rules, anytime someone's patient health information is going to be accessed, certain software will assign basically like an audit trail. So if someone's information is accessed 10 or 15 times while they're in the hospital, each one of those accesses, whether it was just to put a note on the record, whether it was to check on a medication, all of those basically are listed in an audit trail. And depending on the software, that can have the specific user's name and the purpose for which the information was accessed. And again, under the old rule, this wouldn't have been part of the accounting, but now it is. And I guess by way of background, as a patient or as someone that has your protected health information held by a covered entity, you can go to that covered entity and say, I want an accounting of all the disclosures that you've made of my protected health information. So you can go to your doctor and say, give me this accounting, and your doctor within a time period has to provide you with a list of all the disclosures they've made.
Is there allowance for billing for that?
No, there's not. Actually, yeah, there is an exception for billing. I'm pretty sure.
I mean, to charge the customer to do that.
Can you charge? Usually, I'm not completely sure, but I think you can charge an administrative fee, and you can usually charge for copies. But that's it. You can't charge them for the report, but you can charge them for a certain amount per page per copy fee.
Okay.
So the access report under the accounting for disclosures rule provides or requires that you include a description of the protected health information and the activity that was performed. And it marks a pretty vast departure from the old rule, because as I said, that old exception basically took care of 90% of the reasons that the protected health information would be accessed. So one of the biggest criticism is that this sort of goes beyond the scope of the HITECH Act. The rules go beyond the scope of what the HITECH Act actually intended, because it's basically a pretty onerous burden on the covered entity. And one of the other problems is that the report requires disclosures for all designated record sets, not just electronic health records. Yes, Bill?
I'm sorry. I had a question popped in my mind.
Sure.
Does this include business associates?
Yeah, I believe it does.
Let's use the case of the law firm. So
Yes.
someone working on a case with a business associate agreement. So I mean, every time someone touches that information, well, we account for it. If they were to ask for it, we would have to provide it.
That goes to the fact that once it's no longer an electronic record set, then once you say we print off a copy and send that to the law firm, then that's the access. The access doesn't follow the record. Now, if we get to some point in the future where law firms have the same software that hospitals do, and you can just send the electronic health record over, then in that case you probably would have to provide that disclosure. But the way that I think that this is probably going to be used more and more in the future is, right now in your if you're in a medical malpractice lawsuit, one of the questions that any plaintiff's attorney is going to ask is to provide names and addresses and contact information for anyone who's accessed or treated the patient who's suing the hospital, doctor, or whatever it may be. Well, under this accounting for disclosures rule, the patient could just go to the hospital and say, give me the accounting for disclosures. in the hospital or the doctor would just have to give them a list of everyone who's accessed their information. So you basically have a spreadsheet or a printout that has all that information and everything, basically in one easily generated report. So it's probably going to have not a huge effect on the outcome of litigation, but it's going to have an effect on how easy it is for a plaintiff's attorney to find out who's accessed a patient's record. So, for example, say you've got a case where something goes wrong and a medical staff member, a nurse, goes back in and tries to change a medical record after the fact. Well, that's going to show up on the audit trail, and that's always going to raise a red flag in the mind of the attorney. But again, the criticism of this, other than the fact that it just goes above and beyond, what HITECH was originally intended to do, was that it also applies to designated record sets. So it's not just providers that keep everything as an electronic health record. You could also be a provider that still relies primarily on paper records, but say you have a designated record set that tallies patients' names and treatments and bills. Well, that would be considered a designated record set, and you would also have to provide an audit trail or an accounting of any disclosures that are made based on that record as well.
Are there any exceptions whatsoever, or you're saying all disclosures, period?
All disclosures, period, now.
So all the exceptions are gone?
Yeah, it basically wiped out the exceptions.
Okay.
So it's a pretty onerous rule now.
I work for the Medicaid Fraud Control Unit.
Yeah.
And we've always had an exception when we go get health records because we're doing an investigation.
Right.
If they in turn, which aren't done in a day,
right.
These kind of investigations, a fraud investigation would take 2 years.
Sure.
So if 6 months after the investigation they fire off a report to the provider that doesn't know they're being investigated, and it says HHS and Medicaid Fraud Control Unit access their records, that's a clue.
Right. Right, it would be.
You're saying it's going to be in there now?
I think that it would be. Did you if you fall before, did you fall into the operations exception? There's the treatment
or healthcare oversight.
TPO.
Oversight. Yeah. I think that would be included. Like I said, this rule was just, I think March is when the final rule was announced, and then they had the comment period, and it's not actually going to be effective until next mid-2012. I don't think there's actually been a date assigned yet, but it's a pretty radical departure from the old from the setup right now. And with that, is there any other questions, Bill?
Is there any, will the roll this back in any way, as far as you can see? Is there any special interest group that's talking about rolling the HITECH back at this point? Or attempting to?
Well, I don't know about HITECH, and I mean, of course, the Obamacare is subject to challenge very often, but to the extent that HITECH is related to that, I don't know if a complete repeal of the American Reinvestment and Recovery Act would affect. I mean, obviously, a complete repeal would affect the HITECH Act, but I would imagine a lot of these protections and new rules would probably stay in place. But again, it's pretty hard to predict.
Has there been any of this been litigated as far as the new rules?
As far as not the accounting for disclosure rules, because they've just been announced relatively recently.
Or has there been any business associates who have been punished under the extension of the rules today?
Not that I'm aware of. But we try to follow that pretty closely. So, any other questions? All right. Thank you all very much.
Thank you.